cases involving access to the courts. And this is because access to the courts is a fundamental right. The court also emphasized that the remedies required by the states under Title II are not unreasonable. Under Title II, states and local governments have to make reasonable accommodations to permit people with disabilities to exercise their fundamental rights. The decision detailed the extensive history of discrimination against people with disabilities in public access, including access to courthouses. So this area is still complicated. I think probably whole college or law school curricula are dedicated to the issue of sovereign immunity, and it seems to be changing. But Tennessee versus Lane makes clear that state governments can be sued for violating Title II, and they can be subject to monetary damages as well as injunctive relief. And it also holds that access to the courts is a fundamental right. So how can courts make sure people with disabilities have access to the court programs and services and activities? As you know, probably when you close your eyes and picture a court, unfortunately, you picture sort of the old stately building, probably with a set of stairs, and most of these courthouses were built before the Americans with Disabilities Act. So our hope is that's where court disability coordinators come in. I'm going to be saying CDCs as short for court disability coordinators. So how many people have heard of CDCs? See, maybe half the group is raising their hand. How many people have needed accommodations from court, either for themselves or for family members or for clients? I'm seeing probably about 6 or 7 hands. Yeah, this is a very important issue, and it can be intimidating and difficult sometimes to make sure that the court knows what you need and to make sure it will be in place when you need it. So the Americans with Disabilities Act regulations actually require that public entities with 50 or more employees have an ADA coordinator and a complaint procedure. That contact info should be public. Public to us means posted in the courthouse, on the website, on a jury summons. It should be places where people will be able to access that information easily. The ADA coordinator for the courts in Illinois are called court disability coordinators. So every judicial circuit and county court system in Illinois has a CDC. We recommend a CDC in every courthouse because they know the details of the courthouse. They know where the problems are. They also hopefully know the local area. So they know how to get qualified interpreters at short notice. And hopefully they are in touch with any local disability rights organizations to sort of stay up on issues and trends. CDCs are appointed by the Chief Judge of the Judicial Circuit, and our bureau, the Disability Rights Bureau of the Illinois Attorney General's Office, has a list of CDCs and also provides training and technical assistance. I've been joking that this is CDC month. I took my show on the road earlier this month. I was down in Carterville, I was in Springfield. I'm going to be presenting to judges at the Judicial Education Conference in February and April, so I attended the training for that. And then we have a local training in Chicago for local court disability coordinators and court disability coordinators in Northern Illinois happening next week. So we provide technical assistance. We're not providing legal advice to CDCs. We have a sort of unique position where we try to remain neutral but make sure that CDCs are educated and aware of the law and are provided the assistance that they need to make the right decisions. And as I mentioned, we have a list of CDCs. If you're looking for the CDC for your courthouse, you can contact us. Our technical assistance hotline is going to be the last slide. So what do CDCs do? They coordinate the court's efforts to comply with Title II of the ADA. They are resources for judges, court staff, court participants. We really see CDCs as having a pretty large job being the point person for disability issues. Our hope is that CDCs are able to be very responsive to court participants and bridge the gap of knowledge that certain judges may have. Our hope is that CDCs are respectful and educated and ultimately able to make sure that participants have whatever accommodations they need in place so that they can equally participate in court programs and services. CDCs also ensure that the court's policy on access for people with disabilities and grievance procedures are followed. The Illinois Supreme Court has a sample policy on access for people with disabilities. Most judicial circuits in Illinois have adopted this policy. The policy also includes a grievance procedure, so if someone is denied an accommodation or auxiliary aid, they have the opportunity for the court to hear their response to that. There is also a reasonable accommodation request form. I'm seeing a hand in the back, yes.
I'm sorry, does the CDC have power to enforce what the DOC thinks is the offender if the judge says, I don't want that accommodation?
Yeah, so the question is basically, does the CDC have power to enforce what they think the ADA requires if there's a judge that is maybe pushing against him or her? You know, it's not 100% clear. I wish the DOJ would come out with like a statement on court access and say, here's what this requires, here's who has the ultimate say. But when we do these trainings, we do tell people if the judge is wrong, we need to go over the judge's head and get what needs to happen done. And so, you know, that would be in cases where it's very clear-cut, it's obvious. The judge thinks that pen and paper is fine to communicate with someone who is deaf and doesn't want an interpreter in his or her courtroom. And so in those instances, we have our office as a resource. The administrative office of the Illinois courts also has a point person for CDCs, and they're able to play a sort of mediating role between CDCs and judges when necessary. But I will say on the whole that it has not been our experience that judges are not willing to grant reasonable and necessary accommodations. And on the whole, CDCs do feel empowered after these trainings to you know, make the right decisions and you know, educate judges. You know, some CDCs are presenting to judges at their individual courtrooms on exactly the issues that we're talking about today. So I'm hopeful CDCs have the power, even absent a specific grant of power that is 100% clear, but that's a great question. So what does court access entail? Today I'll be touching on effective communication, reasonable modifications, and accessible facilities. I would say that the most common CDC issues fall into these three buckets. So first, auxiliary aids and services. So the court must take appropriate steps to ensure effective communication with people with disabilities. The court cannot charge for any auxiliary aids and services it provides. Which auxiliary aid and service is going to be appropriate depends on the nature, length, complexity, and the context of the communication and the person's normal method of communication. In a courtroom, if a person is deaf, they 100% should have an interpreter all the time. Courts must give primary consideration to the individual's request. Here is one example of how Title II differs from Title III. You know, Title II, you have to give primary consideration to the person's request, which essentially means granting it. The court must pause the proceedings until the services are available for effective communication. And the entity, so the court, also has a continuing obligation to check in and make sure the auxiliary aid is actually effective. Who is entitled to effective communication? So we talked about the language of Title II. It covers qualified individuals with disabilities. So who is qualified when it comes to court proceedings? The case here is a recent one from Indiana. So was the adult son of a criminal defendant who was a court spectator that was not directly involved in the proceedings entitled to an American Sign Language interpreter to attend his mother's court dates? Yes. So the court's right the public's right to attend criminal proceedings is among the fundamental rights of access to the courts. That's that Tennessee versus Lane language. The court held it was not an undue burden to provide an interpreter to the son on a limited number of occasions. The son was denied effective communication and the opportunity to enjoy the benefits of the court services, programs, and activities because he did not have a sign language interpreter. And what's interesting about this one is also that the mother has an associational standing claim to challenge the court's discrimination as well, because she wasn't able to talk to her son about her proceedings. So, since courts are open to the public, anyone essentially is able to attend these public proceedings, and so anyone should be able to receive effective communication. Probably the most common request for accommodations or effective communication in the court system would be requests by people who are deaf for qualified interpreters. So qualified interpreters is the language from the ADA, but Illinois Supreme Court policy and state law require certified interpreters, and they require that the certified interpreter have a master or advanced level license in order to interpret in the courts. The Illinois Supreme Court has a language access policy that was amended last September that makes this crystal clear that all court proceedings require a sign language interpreter who is not just qualified but also certified and has the requisite license. We are educating CDCs that the best practice is to have 2 sign language interpreters for longer proceedings, for trials, because sign language interpreters can fatigue. It's a very demanding job to interpret, and also they can check each other's work. And we also emphasize, and so does the policy, that courts cannot rely on family or friends. Cannot rely on family or friends. Bears repeating. So, you know, family or friends may not be qualified, they may be biased, they may be anxious, and it's inappropriate to rely on family or friends. So this slide says, always seek interpreters from the AOSC registry, and I have a picture in the slide of a headline from the New York Times. It had the headline says, sign language interpreter warned of pizza and bear monster at Irma briefing. And it has a photo of a press conference with an interpreter wearing a yellow polo shirt and apparently interpreting instead of the Irma warnings about pizza and the bear monster. So again, my understanding is this was an employee, and it was sort of a last-minute decision to have the employee provide sign language interpretation during this briefing on the hurricane. You know, dead giveaway, he's wearing a yellow polo. Interpreters usually do not wear bright, flashy colors. And you know, you don't know what qualifications someone has if you yourself do not communicate through sign language. And so we really emphasize follow to our CDCs and the courts. Please follow the Illinois Supreme Court language access policy and make sure you are using a qualified, certified, licensed interpreter. Yes, question.
Have there been issues that you're aware of where the courts are saying they will provide the interpreter through video remote interpreting as opposed to a live interpreter?
That's a great question. So the question is about video remote interpreting in the courts. We don't recommend video remote interpreting in the courts because there's just too much going on. Video remote interpreting can be good for sort of one-on-one interactions. I hear it can be helpful in counties where there really is a dearth of sign language interpreters, or for sort of last-minute proceedings. Someone's, you know, has a bail hearing. But we are recommending against video remote interpreting. I have heard from at least one county that they are using video remote interpreting in very limited circumstances. Specifically, they're using it for surprise probation appearances. So showing up to someone who's on probation's house, sort of last minute, in the middle of the night. They're doing that with VRI, which is pretty different from using it in the courtroom. We're going to continue to see what happens with VRI, but at this point we're not recommending it because there's just way too much going on in the average courthouse. But we are also cognizant that we are hearing that sign language interpreters can be very hard to get in rural areas and on short emergency circumstances. I don't think that the AOIC, the Administrative Office of the Illinois Courts that puts up the language access policy, has come out with anything about VRI just yet. But yeah, it continues to be something we're looking at,
one thing,
not recommending.
To the extent that they want to look at it, I mean, I think there's been a recent DOJ settlement that talks about if you do use VRI, the limited circumstances and like the bandwidth that has to be there and all the different things. And so I think some standards are starting to be created and talking about it being, like you said, in a limited basis, and if you do use it, how people need to be trained and all the different factors. So to the extent we can sort of influence that, I think that might be helpful.
Yeah. And California actually has a court guide that's specific to VRI as well. So yeah, we'll continue to look at it, but we have definitely made clear VRI is not a replacement for in-person live interpreters. So another common auxiliary aid is communication access real-time translation, called CART. Essentially, a CART captioner uses a court reporter stenography machine in a computer to display everything that is said word for word. We have a CART captioner here today. We make clear CART is not an official court transcript. The Illinois the Illinois Deaf and Hard of Hearing Commission, IDHHC, maintains a list of CART providers, and so we recommend that CDCs and the courts use the CART providers from the IDHHC list. Another common auxiliary aid would be an assistive listening device. I have a picture on the screen of a very simple assistive listening device where basically someone speaks into a small microphone that transmits what's said over to receivers that are worn by people who are hard of hearing. A headset is plugged into the receiver. Again, this is a low-tech version. Assistive listening systems are also available in the newer courthouses. These transmit what's said through infrared systems and induction loops using technology I cannot explain right now. But again, these are examples of auxiliary aids to make sure that what is said in court is able to be understood by folks who are deaf and hard of hearing. Accessible court documents. So the court has an obligation to ensure that documents are accessible to people with disabilities. So this means providing documents in whatever way the person requests, as long as that's reasonable, including large print, braille, audio recording, or other formats upon request. I've highlighted a recent DOJ settlement here on this slide. Attorney Tom Ross is blind. He was representing a plaintiff in a civil matter. The court required that PDFs be filed electronically. Mr. Ross sought the documents in the searchable electronic format. They were provided only after 14 months of delay. An article about this case noted that opposing counsel had already been accommodating Mr. Ross. It was the court that was not accommodating Mr. Ross. So the settlement with DOJ and the Orange County, Florida Clerk of Courts from 2014 requires that the Clerk of Courts make sure that their web pages and applications comply with WCAG 2.0 AA. So there's no official standard for what makes a website accessible. WCAG 2.0 is probably the closest to it. I think federal contractors are required to follow it. At this point, it's the gold standard, but DOJ has not officially said that. But nonetheless, we are recommending to courts that they follow WCAG 2.0. We're making sure that courts that have websites and also that have documents available on their websites are thinking about how someone who uses a screen reader would be able to access their website. You know, making sure that there's no flashing content for someone who has epilepsy, but basically that CAG 2.0 is followed to the best extent possible. The settlement with DOJ also required that there be a procedure to request court documents in an accessible format. Thankfully, Illinois already should have that. Our court disability coordinators would do that procedure. The DOJ settlement also required that a person be designated responsible for electronic and website access. So, you know, basically, if there's a webmaster, that the webmaster have this on their radar. That there be training on CAG 2.0 for the employees and the contractors, and also the DOJ settlement required that $10,000 in damages be paid to Mr. Ross. So shifting gears, another big topic in court access for people with disabilities are reasonable accommodations. Essentially, courts must make reasonable modifications is the word that's used in Title II, but it's generally referred to as reasonable accommodations. Courts must make reasonable accommodations to policies, practices, and procedures when a person with a disability requests that those changes be made, unless to do so would fundamentally alter the nature of the service program or activity. I also have language from Tennessee versus Lane. Failure to accommodate persons with disabilities will often have the same practical effect as outright exclusion. And the failure to provide a reasonable accommodation is explicitly discrimination. We caution CDCs to be sure that they understand what is being requested. So we recommend that CDCs really understand what the request is, when it was made, and so we recommend that they fill out the reasonable accommodation form. But we are clear when we do these trainings, there's no specific way that reasonable accommodations necessarily need to be made. They can be made verbally, they can be made before the judge on the very first court date, or they could be made weeks in advance. The Supreme Court form is pretty straightforward, but still we emphasize to CDCs that the form itself can be a barrier, and we don't want the form to be a barrier. So we recommend that even when there is an oral request, the form be filled out so that there's a record, so the person has a copy of the form, and that the CDC assists the individual in filling out the form so everyone's clear on what was requested and when. Reasonable accommodations generally need to be requested either by the person who needs the accommodation or by someone authorized to make the request on their behalf, unless the need is obvious. If it's obvious someone needs a reasonable accommodation, then the court will be deemed to be on notice and have an obligation to accommodate even absent a specific request. We educate CDCs on a reasonable accommodation framework. So thinking through, is it reasonable? So this is fact specific. Consider the cost, the administrative burden. Does it impose an undue burden, not just any burden, an undue burden in light of the overall program's finances? Is it necessary? I see hands.
I have a question about that. In my reading of the provision requiring reasonable modifications, there is no undue burden transfer. I may have coming wrong.
So it's a little tricky. So effective communication has the undue burden regulation aspect to it, and existing courthouses also has the undue burden. But still, the idea of reasonable sort of captures the cost that's involved. So for better or worse, reasonable does invite the cost that's included. And that there's a Supreme Court case that I'm not thinking of right now, maybe R-Line, that also sort of makes this point that reasonable looks at the cost that's included. But it would be great if we had more specific guidance on this sort of thing. It does get complicated and sort of convoluted. But still, reasonable invites the fact-specific consideration of costs. Is it necessary? So does it require a nexus, meaning a connection between the functional, or is there a nexus, meaning a connection between the person with the disability's functional limitations and the requests that they've made? Is it a fundamental alteration? So there's no list of what a fundamental alteration is. In some ways, it's sort of a philosophical question of, you know, what is the nature of a court proceeding? Generally, if it would change the essence of the adversarial process, we caution CDCs to be wary of that, and that is something that you know, maybe they need to explore other accommodations, or need to follow a procedure that we'll talk about in a moment, where basically sort of unusual accommodations are heard on the record. So to back up for a moment, most accommodation requests that are made are going to be considered administrative. So the CDC is able to grant them without needing to get permission from the judge, or make it a part of the court proceeding. But there are some sort of unusual accommodations, and we'll talk about them shortly, these testimonial accommodations, where probably the best procedure is to have it on the record so that the person who is denied the accommodation or the opposing party who objects to the accommodation has the opportunity to have their day in court about whether that was proper. And finally, if the court can't grant the specific request, they should open a dialogue. So, you know, the idea of opening a dialogue comes from Title I, the employment provision, but it has been imported into Title II as well to make sure that the people, essentially the court, who are in the position to know what accommodations are possible, can't just bury their head in the sand and say, no, 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 no. Instead, they have to say, all right, we can't give you what you've asked for, let's talk about what we can give you. So examples of what may be reasonable accommodations. I have the word may underlined to make the point that this is fact-specific and context-specific. So the first example here, extending a briefing schedule. Maybe the first request related to a disability, the second request, third request, maybe those are reasonable, but maybe the 10th request related to a disability would not be reasonable. Other examples of what may be reasonable include taking more frequent recesses and adjusting the duration of hearings, adjusting hearing times. I know in Chicago it can be practically impossible to get on public transit during certain times, so it may be a reasonable accommodation to request, instead of a 9 a.m. court meeting, a 10 a.m. court meeting, or even to request to appear by teleconference if it's routine. Allowing food, drink, medication, or medical supplies into the courtroom could be reasonable. Modifying security procedures and electronics policies may be reasonable. Permitting a support person to sit next to a litigant may be reasonable. We do have to be clear, though, that the support person should not be addressing the judge unless that support person is also a lawyer. Relocating hearings so restrooms are easily accessed. This is especially important in older courthouses where maybe only one set of restrooms is accessible. And allowing appearance by teleconference for routine hearings may also be a reasonable accommodation. Filling out court forms at the person's direction may also be a reasonable accommodation. So we get questions about this because folks that work for the courts are very uncomfortable with the idea that they might be providing legal advice. We are clear that this is not legal advice. But the person with the disability who is directing the person to fill out the form has to tell them specifically what to fill out. There's no wiggle room, do what you think is best. It's, please tell me if I'm checking box yes or box no, tell me specifically what to write. Helping someone understand a form without giving legal advice can also be a reasonable accommodation. Allowing use of a service animal or a miniature horse can be reasonable accommodations. So, you know, a service animal is any dog that's individually trained to perform work or a task for the benefit of a person with a disability. We also emphasize that even if the animal doesn't meet this definition, it may still be necessary as a reasonable accommodation. If there's someone that can only participate in court proceedings with their emotional support animal that doesn't provide doesn't perform work or a task, it may still be a reasonable accommodation to permit an emotional support animal, for instance. Yes.
A number of years ago, we actually had an issue with one of our clients getting into the Cook County Court Clearly Center, and they ended up adopting a policy, the chief judge there for Cook County. And I was wondering if other courts, do they have specific policies on service animals, or is that more of a ad hoc kind of thing?
Yeah, that's a great question about whether essentially other courts are maybe required to have service animal policies, or whether they have adopted service animal policies, because Cook County has. I'm not aware of other courts having adopted service animal policies, but we actually do recommend that they do have a service animal policy in place, and also that they have a policy that talks about miniature horses and considers the different reasonability factors in the statute or in the regs. But I'm not aware of there being service animal policies in other courthouses. Yeah. Yeah.
There's the creative disability for community to talk about nutrition of the people that the house or the service and the rules that community disability guards up there informed about the service animal.
So the question is whether our court disability coordinator trainings also talk about making sure that CDCs are educating other folks in the courthouse, such as security guards. The answer is yes. We definitely emphasize that. We actually have, in addition to CDCs attending the training, we often have people from the sheriff's office attending, who tend to be the folks in charge of security for the courthouse. But yeah, we definitely make the point that it's not enough that there just be one point person, but they really have to equip frontline staff and other folks that are going to be called upon to make sort of split decisions. But at this point, the sort of our model is educate the CDCs, and the CDCs should go educate the rest of the courts. So testimonial accommodations, I sort of previewed this earlier. So sometimes CDCs get requests for accommodations to help someone testify. So unfortunately, people with disabilities are about 2 to 3 more times likely to be victims of violent crime than people in the general population. I have an example here. I wanted to highlight one court's approach to testimonial accommodations. This is a case from Massachusetts, my home state. This is probably my favorite judge. She was the author of the Goodridge same-sex decision. She has a great fair housing case, Carter versus Lynn Housing Authority. And so this case is In re McDonough. So here, a woman who was attacked by her caregiver wished to testify against him in court. Because of her communication disability, she had aphasia, she could not provide narrative answers. The trial court judge determined she was not competent to testify against her alleged attacker. So this case presents some interesting issues. So is a witness entitled to testimonial accommodations? And how are those squared with a criminal defendant's rights? So, imagine she doesn't want to be subject to cross-examination. Is that reasonable? Is that a fundamental alteration? If it's granted, how does that impact the criminal defendant's right to confront his accuser? So ultimately, the court decided yes, a witness is entitled to accommodations necessary to permit her to testify. The way that they sort of broke down what accommodations will be granted and how is that these issues should be on the record with the parties weighing in. So first, the witness or the party that's proffering the witness should alert the judge and the parties regarding the need for the accommodation and should make a specific request. Next, the judge should resolve any objections during a hearing, and on the record, the judge should question the witness on the need for the accommodation, what accommodations might enable her to testify. The judge could call for expert testimony, and ultimately the judge would make findings to permit appellate review. So again, I think CDCs can grant most accommodations because they're going to be administrative. But for these sort of tricky accommodations that are arguably a fundamental alteration, this is one way to address that. And I think this way is hopefully fair because everybody gets to weigh in. And ultimately, you can have your the issue resolved on appeal if we disagree. I have language here from the case. It is incumbent on all judges and judicial staff to ensure that every person with a disability be provided with reasonable accommodation, if available, to ensure that she be a full and equal participant in our system of justice. There's a law review article that mentions this case, and on remand, the witness's lawyer filed a motion for accommodations. Ultimately, the witness was allowed to testify with the following accommodations. Lawyers asked single subject questions that called for a yes or a no response. The witness was allowed to use gestures and diagrams, which is usually a no-no in court. Usually you have to speak your answer. The witness was allowed extra time to respond, and an expert in aphasia was allowed to testify about the witness's disability. So limits to what the court must provide. Courts are not required to provide personal devices, personal care assistance, readers for personal use or study, not required to provide additional services for people with disabilities that are not provided for people without disabilities. But even if a request is made that the court is not required to provide, there should still be opening a dialogue to talk about whether there is something they could provide. Courts can have legitimate safety requirements and can deny service to someone who is a direct threat, but that cannot be based on speculation, not based on generalizations, not based on stereotypes. It must be based on actual risks. So the court is not required to take any action that it can demonstrate would result in a fundamental alteration or in undue financial and administrative burdens. That decision must be made by the head of the public entity or his or her designee, must consider all resources available for use in the funding and operation of the program. The decision must be made in writing, must include reasons for reaching that conclusion. They must prove, they have the burden of proof of proving that compliance would result in fundamental alteration or undue burden, and they must, again, consider alternative means of providing program access. Okay, moving right along, we're at 1016. Accessible facilities. So probably this is our third bucket of common issues and requests that court disability coordinators receive. So as I mentioned, many courthouses in Illinois predate the ADA. Our final topic today is going to talk about courts' obligations to provide accessible facilities, essentially to provide program access. So new facilities, so built after January 26, 1992, must be readily accessible, which means they must comply with applicable accessibility standards. So for federal law, that means ADA and the applicable ADA standards. For state law, that means the Illinois Environmental Barriers Act and the Illinois Accessibility Code after May 1st, 1988. I will ask Laura Paul's favorite question. Has anyone here heard of the Environmental Barriers Act? Please raise your hand. Okay, maybe about 6, 7 people. Illinois Accessibility Code, anyone heard that? Maybe more people? I think maybe slightly more hands have gone up. And also, new facilities must comply with local codes. So altered facilities must comply to the maximum extent feasible, and existing facilities that predate the ADA, well, that's the lowest standard. So under Title II, we're talking about program access. So readily accessible when viewed in their entirety. There is an undue burden defense available for these existing facilities. There is no such thing as being grandfathered in. This is true for Title II and for Title III. This is probably the top thing that we hear. Well, our courthouse is grandfathered in. No, it's not. So under Title II, existing facilities must provide program access. So what does that mean? That means that people have to be able to access all of the programs, services, and activities. It doesn't necessarily mean removing all physical barriers, such as stairs. But the programs have to be accessible to people that are unable to use an inaccessible existing facility. That can be done by relocating programs and services, providing them in alternative methods, and sort of thinking outside the box. But we also recommend people just think about making the structural changes. Fix it. You don't have to worry about making sure that you've given proper notice that this proceeding is going to happen someplace else. Fixing it can often be the most effective and can save you the most time in the long run, even if you're not strictly obligated to do so. Are historic facilities exempt? That's the other thing we hear. Well, we have a historic courthouse, so we're fine. Well, no, not anymore. So this is an older case, 1998 of Arkansas. A courthouse was listed on the National Registry of Historic Buildings. There were no elevators, no ramps, no other means to access the second floor. Just like George Lane, this plaintiff had to be carried upstairs. He had to crawl downstairs to leave. He was unable to use the restroom for hours. He was unable to leave to buy lunch. Pretty egregious facts. So one of the issues in this case was considering, are historic courthouses exempt from program accessibility requirements? The answer is no. In this case, the judge actually granted motion for summary judgment on liability, holding that the county had failed to make its services, programs, and activities readily accessible to and usable by people with disabilities. The ADA regulations speak to historic facilities. They say there's no obligation to take action that would threaten or destroy the historic significance of an historic property. So what this essentially means is, if someone is trying to argue, I don't want to have to change the staircase in our building, well, you better show that staircase is historically significant. And I think it would probably be kind of hard to prove that a certain staircase is historically significant. And there really can be ways to make accessibility improvements without taking away from the overall aesthetic of a historic facility, and that is required under the ADA. Primary accessible elements. I'm going to speak very briefly on these topics. So basically, this is just a list of what are the high-level key areas to consider when you're evaluating whether your courthouse is accessible. We tell people to think about parking. So is your parking on the shortest accessible route? Is there an adequate number of it? Is it clearly marked? Think about signage. Are your accessible features clearly designated? Do you have directional signage so people know how to get to the closest accessible restroom, entrance, etc.? We recommend that the signage be located so that you don't have to backtrack. So if you have an inaccessible entrance, you mark way up front that entrance is not accessible and the accessible entrance is around the corner, rather than requiring someone to get all the way to the entrance and then realize it's not accessible. Turn all the way around. An accessible route, that's a continuous, unobstructed path that connects all accessible elements or facilities and spaces, gets you from the entrance to where you need to go. There should be an accessible route in every courthouse. Entrance, 60% of public entrances should be accessible. That means level, no step required, clear width of, I think, 32 inches, compliant door force, not too heavy to push open, and compliant hardware. Accessible restrooms, pretty self-explanatory, hopefully, grab bars, the ability to get in and turn around in your wheelchair. Also compliant hardware so that you can use the facilities. Accessible counters, so lowered counters with knee and toe clearance if they are supposed to be writing surfaces. Accessible courtrooms, this can be tricky because most courtrooms have raised features such as a jury box, or sorry, a witness box, or the jury box. So think about how someone who uses a wheelchair would be able to get in there to testify. You can do that with lifts. You could put in a ramp. And if it's an older existing courthouse, then you do have the ability to think about program access solutions. But when thinking about program access solutions, we really emphasize that you also have the obligation to provide services in an integrated setting. So however the person with a disability is going to testify should be how anyone is going to testify. But unfortunately, sometimes for older courthouses, they do have to think outside the box and provide solutions that are not ideal. But courthouses also have the obligation to sort of on an ongoing basis be evaluating their programs and services and facilities. So if it's not financially feasible to address the step into the jury box this year, it should be on your long-term plan to fix it in the future. And that's another task that CDCs have, overseeing self-evaluation and transition plans for older courthouses, really for all courthouses that have any sort of accessibility barrier, including communication barriers. Finally, emergency planning. Emergency planning should involve people with disabilities. It should also make sure that if in case of emergency, people with disabilities can be safely evacuated. Planning for emergencies needs to involve people with disabilities from the beginning. It needs to be part of all of their planning. It can't just be tacked on at the end. People with disabilities need to be part of these conversations. So finally, we have some resources on effective communication. Illinois Deaf and Hard of Hearing Commission, Administrative Office of the Illinois Courts. They have a language access specialist who can help courthouses make sure that the court is providing effective communication. The American Bar Association has a fantastic guide that they came out with recently. It's about court access for people who are deaf or hard of hearing. We also have resources on accessible facilities. The Access Board has a advisory committee on accessible courthouses that put out back in 2006 some findings. They also have accessibility animations. These are sort of short explanatory videos that I think are really helpful for folks that are just becoming familiar with what the accessibility guidelines require. So they have a great animation about accessible restrooms, for instance, that will hit on all the different issues and can show you what a turning radius is, for instance. And then DOJ has some other materials that can be helpful, but nothing specific to court disability coordinators, even though I would love that. We also, ourselves at the Bureau, have a court disability coordinator manual. We've just updated it. It's available on the website. We highlight some cases in here. We talk in depth about effective communication, accessible facilities, reasonable accommodations. And finally, if we have any questions, happy to take those, and I'll put up the slide with the contact info. Marcia?
You have not mentioned the role of the accessibility features for people who would be potential jurors. Are we covered by Title II?
That's a great question. The question is whether potential jurors are covered by Title II. Yes.
Okay, I have another. I have to give you my odyssey. Please be patient.
Yes.
I was assigned to the Meghan court. This was maybe 2.5 years ago. Well, I arranged with paratransit to get there, and I had to put the return time at 4:30 or 5 because I had no idea. So I get there, and the door's not open because, of course, I got there early and I'm sitting outside. So finally, they let us in. And they said, "You must stand behind this line." Well, I certainly didn't see a line, and it was a tape on the floor. And I said, "Well, I'm really sorry, but I can't stand for 25 minutes. Is there a place I can sit?" No. So I decided to sit on the floor because I can't stand. So finally, another staff person took pity and brought a wheelchair so I could sit. Then it was time to go through security to go into the big room. And the man said, "Okay, come this way." And then it was very silent, moving ahead. And so I had to guess where I was going. I had no accommodation, no help. Now I use a white cane. I had no help. I got to the briefing room, and I'm sitting there, and they're showing a video which did have audio, but there were times when there were things happening and it was just music or people, people walking or something. I don't know what it was. It was the audio with Tim Evans and those people. Anyway, so then when it's time, they don't tell us anything until it's lunchtime except, "We don't need you today, you can all go home." So everybody ran out, and I'm trying to find my way out because the guy who was sitting there left, and some of the people took pity on me and took me out.
And I said, well, you know, are there any buses? No, there are no buses till 5 o'clock. This is Maywood, and we have pigs. There was no way to get out. I could not stay in the courtroom because it's only for employees during lunch hour. I had to sit outside. Finally, I found a couple other wanderers, and we had to actually figure out a way to get a cab to then get us to the Blue Line so that we could get back into the city. Now, I don't think any of that's acceptable, but this kind of thing happens. Also, when I get a jury summons, can I expect one or can I request one in an alternative format?
Yes. So to hopefully capture what you've shared, first of all, I'm so sorry that happened. Marcia was sharing that she was assigned to jury duty in Maywood. She was asked to stand behind a line that was marked on the floor that was not clearly evident to her. She was asked to stand for, it sounds like 25 minutes or so, which is difficult for you to do. Staff eventually brought you a wheelchair, so you were able to sit after some time. And then it was unclear where exactly you were being asked to go, and people weren't offering you assistance. And then there was a video that had audio, but not audio descriptions to capture what was happening on the screen. And you also had transportation issues getting there via public transportation. And then finally, you were wondering if you could request the jury summons in an alternative format. So you can absolutely request the jury summons in an alternative format. And you should absolutely reach out to the Cook County Court Disability Coordinator. So in Cook County, my understanding is each courthouse has a CDC, but there is also one overriding CDC named Kate Brandt, who is wonderful. And I will email you her contact info. But basically, you know, these are the kinds of situations that I'm really grateful you're able to share, because my hope is to share them with CDC so that they can look at their court proceedings with, for lack of a better phrase, like disability goggles. You know, how would you view this coming from a different perspective? I think, you know, unfortunately, for better or worse, a lot of court programs do ask people to stand for long periods of time, and they aren't necessarily looking out for ways to be helpful, for lack of a better phrase. And what we really try to emphasize to CDCs is, hey, this isn't you being a nice guy, this isn't you being helpful, this is required by the ADA. This is required. This is not you going out and doing something nice. This is a reasonable accommodation. You must do it if it's reasonable. So I'm so sorry that happened. I think hopefully in the future, if you're able to reach out to a court disability coordinator, they can get in touch with the CDC, who can maybe meet you next time and provide you any guidance that you would like. But my hope is that the longer that the CDC program exists, the fewer instances we'll hear of, you know, I needed to ask for the opportunity to sit, or they said no, or, you know, it was completely unclear to me what was being asked and where I was going. Because my hope is that CDC will work to build more inclusive experiences from the get-go.
If they see a white cane, someone has to step up and ask me what I need.
Yeah.
And that is a simple conversation. You know, it would be successful. I have one follow-up question about jury, and that is, if there's something visual that's shown as part of testimony or evidence or whatever, what kind of reasonable accommodation could I, as a visually impaired person, expect?
That's a great question. So the question is essentially, if someone who is blind is on a jury, what kind of accommodation would be possible to make sure that any sort of visual information is able to be conveyed? So there's actually conflicting case law about whether it's proper to exclude a potential juror who is blind from a jury. There's a case that says, you know, absolutely that's inappropriate. You should be able to accommodate someone who is blind. And then there's a flip case that says, well, we kind of got to look at what the testimony is. Is there going to be a large amount of testimony and evidence that can really only be conveyed visually? And if so, then it may be proper to exclude someone from the jury based on that. But my suggestion would be, if you want to participate as a juror, which I totally get, I would love to be a juror. Sign me up. I would absolutely love to do that. You should work with the CDC to see what is possible. I don't know if they could maybe assign you to a case that, yeah, I just don't know what's possible. But I think it's worth making the ask.
Is there any information on the jury summons that says to request reasonable accommodation, call this number?
Well, each jury summons is going to be issued by each individual court.
Oh,
I'm pretty sure Cook County does have information on their jury summons.
okay.
Yeah.
So that at least if a volunteer is reading it to you, then I would at least know that it's on.
Correct.
Okay.
Yes. So Marcia was saying if the volunteer is reading to her, they would be able to read that the summons specifically states you can call a specific number to receive it, in an alternative format. My understanding is that yes, Cook County does have information on it.
I actually several years ago had a judge come up, pull me up to the bench while they were doing jury selection, and we were in the courtroom in the seats. And they were calling us to enter us to become potential jurors. And the judge himself requested me to come up to his bench and said, if you want, I can get you out of this.
Yeah. Marcia is sharing that a judge has pulled her up and said, if you want to get out of jury duty, I can get you out of this. We do hear about that a lot. And our hope is that CDCs and judges won't just assume things about people with disabilities. Thank you. Thank you for sharing. Rachel?
I'm able to ask a private question to put my children's asking about kind of thing how considered someone who died. She writing her jury summons to be in the accessible format. She branded this is the she needed it to be in accessible format. It was sent to her. We had to be sent. She appeared to be submitted about it the last 12 months. So we can help her to ask that they should be between someone for jury duty.
Yeah. So Rachel was asking essentially whether it's possible for the different court systems to be able to capture when someone needs something in an accessible format so that it's sent out in the accessible format rather than having to wait for that request to be made. I just don't know. It's got to be courthouse specific based on how each court handles it. Whether or not that would be reasonable, I'm just not familiar with what system they use. And hopefully as technology evolves, you can flag someone as needing a specific accommodation and an accommodation that's not likely to change over time. I agree that it would save a lot of time and effort and ultimately be more compliant if there are ways to mark someone as needing something in a specific way. I don't know if there are small courthouses downstate where there's, it's just like a smaller job to send out the summonses, and there could be just a notation for some folks, but I just don't know that exists right now. But it's a great issue. Andrew?
Yeah. I have a question pertaining to administrative hearings. As far as I can think, all the titles of allegations for testimony discussed would be particularly binding on the state administrative agencies that they are on the court system. So my question is, are the individual agencies responsible for designating somebody within the agency who is the equivalent of a CDC, who is sort of the go-to person for concerns about accessibility?
That's a great question. So Andrew was making the point that for state administrative agencies that hold administrative hearings, he would assume that Title II would apply to those administrative hearings as well, just like they apply to court proceedings in state court. And he's wondering whether individual agencies are obligated to designate someone to be essentially like an ADA coordinator. My answer would be most likely yes, that the ADA regulations require if the entity has 50 or more employees that they designate someone to coordinate their efforts under the ADA and to oversee their complaint procedure. I don't know for sure whether each state administrative agency has an ADA coordinator whose information is publicly available, but my take on it is perhaps a little simplistic, but they definitely should, and that it seems clear to me that the obligation to provide effective communication would be something that would most likely be delegated to the ADA coordinator for the agency. If you're having specific issues, please contact us. The Disability Rights Bureau Technical Assistance Line is 312-814-5684. And we'd be happy to talk with you about what's going on and see if we can help get to the bottom of whatever it is.
Sure. There's also the State Administrative Hearings Department. And I know, back in Scotland, but they do oversee DHS hearings. I'm not sure if they also oversee HFS.
Yeah.
So that page is violation of your CAG disability report. You guys can take that up like outright violation that you just kind of guidance. You should do this, but you not.
So the question is, if a web page is in violation of the CAG 2.0 standards, whether that's like an outright violation or whether it's sort of more of a guidance type violation. There are probably people in this room that know more about website accessibility than I do, and they are welcome to raise their hand. But my understanding is that there's also sort of split case law on this, that there are some courts that say DOJ hasn't explicitly said WCAG 2.0, but it's the best standard right now. It's what federal contractors are required to follow, and a website is a program or a service or an activity of a Title II entity, or it's a place of public accommodation, or something like that. And so the web page does need to be accessible, and accessibility does mean compliance with WCAG. But then on the flip side, there are cases that say, well, until DOJ speaks, we're not going to require these places to become compliant with the standard that could change over time. So we're not going to find that a violation. Or there are cases that say websites aren't specifically places of public accommodation under Title III, and so we're not going to require that the website be accessible. So I think the answer is that it's fuzzy, but that it doesn't hurt to make the ask if you are having problems with obtaining court services or other services because of an inaccessible website. And if folks have thoughts on that, please jump in. Sure.
I know that case law is coming up. A lot of that's Title III case law. Is there any case law in Title II talking about website access? Because you don't have that place of public accommodation as a matter of program access.
So the question is whether there is case law under Title II talking about websites and website accessibility. Again, I defer to other folks that are in the room, but the best example that I came up with, and I think the best example that Barry and Rachel came up with as well, was the recent DOJ settlement that we talked about with Orange County, Florida. I'm just not familiar enough with the area about whether there are specific cases under Title II. Is anybody in here?
There was probably the most prominent case was a case out of Atlanta, the Atlanta Transit. This is an older case, but it was one of the first ADA Title II cases that talked about website accessibility and required, and talked about how program access is different than place of public accommodation. So that's one that a lot of people look at. I mean, I think that it's really, really hard, and I think Megan's absolutely right, that DOJ has not put out regulations, and they proposed them, and we were hoping the last administration would implement them, and they kicked it down the road many times, and the current administration has shown no interest in moving forward on this issue. So what a lot of people argue is that DOJ, even though they don't have specific regulations, in a lot of amicus briefs they have said that websites are covered by the ADA and Title II, so they've said their position without giving the specific regulations, and then when they settle, they always go with WCAG 2.0. And so I think you kind of have to sort of connect the dots a little bit for the courts, but there are dots to connect, so to speak. So it's not ideal, but I think there's arguments to be made. And we here in the Seventh Circuit, there hasn't been direct case law on website accessibility, but there is some language that was dicta in a case that Judge Posner decided on when they were talking about access to insurance policies, and they were saying, well, it's not an insurance office, so that's not a place of public accommodation. And they overruled that, and he said, you know, it's just like a website. It's not a place, but it still should be covered by the ADA. And so that's something that a lot of people, when they're making website arguments in Illinois, would look to.
Christina?
And it seems like there's still a lot that needs to be worked out. People who kind of transition to mandatory e-filing. I'm wondering if your office or the CDC have been involved in trying to help with that transition.
So Christina is making the point that there's a lot to figure out about mandatory e-filing and whether our office is involved in that. The answer is that no, we are not involved in this process, but my understanding is that there are people who are involved that have accessibility on their radar. But yeah, I agree. It's something that, you know, for folks that don't know, the Illinois state courts are all moving to mandatory e-filing. Some already are required to offer e-filing, and some are coming up on their obligations to allow e-filing. I know folks at the AOIC are thinking about e-filing through the lens of disability access. So we'll just have to wait and see, I guess, to some extent. Charlie?
So a couple of things now, and people come back to the daily sector. We've been there for saying, and we're done. And what probably would be about the case, their answers clearly been out of the law now. But also we're telling you that they were told they only had one time that they could have an interpreter in the court, and that if they went back, they would not get an interpreter. They've always been in such deep hot water. I tried to get counsel instead of trying to go back per se, but is there a better place for them to advocate for those experiences? In order to improve the system?
Yeah, so Charlie's sharing that he's encountered people who are deaf having gone to the Daily Center, coming back confused, and told that they're only allowed to have an interpreter once, it sounds like, and wondering the best way to share those experiences and advocate for better communication with people who are deaf. The court disability coordinator for Cook County, honestly, I found her to be incredibly responsive, and that issues facing people who are deaf and hard of hearing are very, very, very much on her radar. Cook County is unusual because they actually have a large number of interpreters immediately on staff. They even have a certified deaf interpreter who herself is deaf and is able to assist with interpreting for folks that have sort of unusual sign language needs. So I can definitely give you her contact info. I don't know Cook County well enough to know if they have some sort of open communication policy or group that's meeting on this, but I would be very surprised if Kate Brandt is not very much open to hearing what happened and getting to the bottom of it.
I know that the Chicago Bar Association, I don't know if it's currently going, but they did have a committee that was working on access to the courts generally. It wasn't a disability specific thing, but just different access issues that come up for a variety of reasons. And I know for a while we've given them some resources and information about who could help on the disability side of things. So that might be a place to reach out to HRA to see what their current status is of that committee or work with whatever it was.
Yeah, I can like that.
Oh, okay, you are. Great, thanks for talking about that. Any other questions for Meghan? I guess I had two quick questions. One is, you mentioned that your jurisdiction is only over state courts because the ADA goes for state local governments for Title II. Do you have any understanding about what's going on in federal courts or what people should do in those kind of contexts, despite the fact the ADA doesn't cover it?
Yeah. Do you have to repeat your question?
No, I'm
Okay.
close enough, but I can hear you.
Just wanted to make sure. So my understanding is that there are federal laws that protect effective communication in the courts. I don't know about whether it also covers reasonable accommodations. I can get you an answer on that, but my understanding is that there are people in the federal court systems that can sort of serve as court disability coordinator types, especially for effective communication. But I unfortunately just don't have that information.
Sure.
I can share a story on that. I was advocating for an individual who was had Francis Grace's law firm for bankruptcy, but couldn't communicate with Francis Grace's firm and just knew she was going to court. And I tried to get a bankruptcy court clerk to arrange for an interpreter. And the clerk initially told me, look, you don't have any obligation to do that. They have to bring their own interpreter. They ended up being able to find the interpreter, but only after continuing the case so they could figure out their own system. And then when the interpreter did show up, the individual wanted to dismiss their bankruptcy, but somehow at the end of the matter, the bankruptcy was not dismissed, it was continued another day, which was against her financial interests. It was like a financial burden for her. So to the extent that the federal court, we're not talking about them, I don't think they should be left off the hook.
And then the only other question I had was, are the CDCs, would you say that that's their primary responsibility, or is it something that's sort of an additional job that's lumped on to another type of position?
Yeah, that's a great question. So Cook County, this has a CDC that is largely just CDC, but also I think there's some employment issues. But in most counties, the CDC wears many hats. Yeah. So you're not going to be the circuit clerk. We've seen CDCs who are secretaries to the chief judge. Some CDCs are actually in the sheriff's office. But it's unusual to have someone who is only CDC. Cook County comes closest to that.
Well, please join me in welcoming. Thank you, Megan, for this presentation. Really great information, and just so I'm clear on the website link that you have here, that when they go to that, would that have a clear link to the CDC, or should we maybe send that out,
sure,
a more
so,
specific link?
This link is the specific link for the CDC manual.
Oh, okay.
It's on page slide 38. The final slide just has the website for the Disability Rights Bureau generally.
Right.
You can get our complaint form there.
Okay. Just a couple quick things. Remember that if you could please complete an evaluation before you leave. Also, those of you who are watching on the webcast, shoot me an email, barryt@equipforequality.org, to confirm that you actually watched the whole thing. And then our next meeting, remember that we usually meet the fourth Wednesday of every month, but that gets challenging with the holidays at the end of November and the end of December. So we always do sort of a merged meeting the first week of December instead. So our next meeting is going to be Wednesday, December 6th at 9:30. We're still working to finalize that topic, and we'll send out an email once that's confirmed. But we won't be meeting the fourth Wednesday of November, December, but instead December 6th, the first Wednesday of the month. Thanks, everybody.
Thank you.
I know.